talking about everything that happened after what he was indicted for. Your Honor heard argument in case law. Your Honor denied that motion and allowed the state to go into it. This is now my case in chief. Part of the defendant's case in chief is to rebut things that were said and made and argued by the state in their case in chief. So it's not like I'm bringing in a new theory or principle. It was specifically because a motion in limine was denied, Judge. And I have no objection to putting Michael Dunn on first, but I would ask that Dr. Abuse would be allowed. And I believe I gave you the case law yesterday, which talks about, it's Allen v. State, 365 Southern 2nd, 456. Says there must always be a first time for everyone, and extensive education is not necessarily a prerequisite to expertise. In order to qualify as an expert witness, one needs only to have acquired such a special knowledge of the subject matter of his testimony, either by study or by practical experience. There's Rose, that was a first DCA case. Rose v. State, 506 Southern 2nd, 467, also first DCA judge. Humble v. State, 652 Southern 2nd, 1213, Florida first DCA. That was a murder case, talks about exactly this. And that talked about post-traumatic stress disorder, and I used it to show that we're not using it for post-traumatic stress disorder. And that issue was a battered spouse syndrome, and back then, it was a fairly new concept, and Dr. Abuso testified that this has been around since World War I, really hit the ground in the 70s. He did his own research in the 80s and so on and so forth. I did cite State v. Mizzle, the M-I-Z-E-L judge, and that actually gives the 5 kind of prong test I would talk to about it, Your Honor. And I think Dr. Abuso's expertise, training, and experience satisfies that prong test, also first DCA. And the last one, Judge, is Conley v. State, C-O-N-L-E-Y, 39, Florida Law Weekly, D24, first DCA 2013, which basically said Fry doesn't exist unless it's new or novel. It's the Daubert, which you mentioned yesterday, Judge, because I think Ms. Corey had said Fry, brought up Fry, but again, this is not a new or novel idea, it's not a new or novel theory. It's twice.
I'm with you. It's you know, apparently if it's mentioned in the MS, I've forgotten what the name of the book is, DMS 4 or 5, whatever we're on, if it's mentioned in there, I take his word for it.
And then
it's not some new science. I agree with that.
Judge, in Chavez v. State, which I believe is Florida Supreme Court from 2009, talks about an expert can be qualified through knowledge, training, or education, and it's not just limited to academic, scientific, or technical knowledge. An expert may acquire the specialized knowledge through an occupation or business or frequent interaction with the subject matter. So that's the predicate that I laid, Judge.
I understand.
Okay, and I do believe I gave Your Honor that case law yesterday.
Okay. Well, I'll let the state huddle a little bit, see what tact they want to take. So we'll be in recess for 20 minutes.
Judge, do you want me to put this deposition